A properly executed authorization may be used to disclose any kind of PHI. The federal rule for authorized uses and disclosures of PHI is Section 164.510. States have different methods of authorizing disclosures of medical information. California's law is Civil Code 5611. State law can be more stringent than HIPAA, as long as it isn't contrary to HIPAA. More stringent means the law provides greater access to PHI or affords better privacy protection. California Evidence Code permits lawyers to obtain copies of their clients' medical records. The attorney must submit a letter and the client's authorization to the provider. The client's authorization must comply with federal and state law. The HIPAA regulation for authorizations has 3 parts. The basic presumption is that no PHI may be disclosed without a valid authorization. Disclosure of psychotherapy notes always requires a signed authorization, no exceptions. Marketing requires an authorization with minor exceptions. If the provider communicates with the patient face-to-face, no authorization is required. Or if the provider is just giving a promotional item of nominal value. The sale of PHI always requires an authorization. A valid authorization must be consistent with the law and must contain certain language. An authorization that's expired, revoked, or has missing or false information is defective. An authorization must not be compound unless it involves research. In that case, the subject's consent may be combined with the authorization. A provider may not withhold treatment if a patient refuses to sign an authorization. A patient's revocation must be in writing. Policies and procedures for the authorization process must be documented. Authorizations must contain 6 core elements. The patient must describe their request in a specific and meaningful way. The authorization must identify who's making the request and who should receive the documents. The statement of purpose can simply say the patient requests a copy of their records. The authorization must have an expiration date according to California law. According to HIPAA law, the authorization may be expired according to an event. The document must be signed by the patient or the patient's representative. If a patient representative signs the document, the authorization must describe the representative's authority to sign. The authorization must include statements regarding patients' rights. The authorization must use plain language. A patient is entitled to have a copy of the authorization. In California, an authorization may be in handwriting. If the authorization is printed, it must be no smaller than 14-point font. Now we'll examine PHI authorizations in the town of Single Peak. The Pruitt Medical Group sits on the corner of the plaza. It's a busy practice with 2 doctors and a chiropractor. Pete, the office manager, recently quit his job and took another job on the other side of the plaza at the computer store that's owned by his friend Guy.
Hey Pete, I'm so glad you decided to come over and join me. I want you to take over the photocopy services.
Should I start by doing some marketing?
Not yet. First we need to cover some ground rules. A lot of our business involves medical information that we obtain through medical authorizations. The authorization document must be valid under California law and HIPAA regulations. You need to go to the county clerk's office to get registered as a professional photocopier. California law requires county clerks to keep a list of professional photocopiers.
Pete obtained his certificate from the clerk, and soon he was talking to his first client.
Hello, this is Pete.
This is Lois Lawyer. Would you come over to my office? I need you to copy some medical records for a couple of clients.
Pete went over to Lois Lawyer's office.
Hi, Lois. I'm at your service.
Come on in, Pete.
What do you need?
Okay, first I need help with Sister Agnes. I prepared her estate plan last month. Now she's in the hospital. One of her nieces wants to take care of her at home until she gets better. The niece tried to get copies of Agnes's medical records, but the hospital rejected the authorization. They said it was defective because the niece wasn't Agnes's personal representative. She didn't have authority to act on Agnes's behalf.
Does Sister Agnes have dementia?
No. In fact, she calls me from the hospital on Skype.
Do you want me to visit Agnes at the hospital?
Yes, please, take this authorization over for her to sign.
Good. I'll take care of it.
Now the next situation is a workers' comp case. The claimant is waitress Wanda.
The authorization is really short. It doesn't look right.
Workers' comp authorizations are exempt from HIPAA. They're governed exclusively by California law. They don't need to include statements required by HIPAA. That's why it looks short.
I heard about Wanda's accident at the coffee house.
Yes, her case is extremely sensitive because Wanda and Dr. Kramer are close friends. Dr. Kramer is also Wanda's chiropractor. We need Kramer's chiropractic records and Dr. Pruitt's initial report of injury.
So, you want me to copy all of Dr. Pruitt's records?
Oh, no, don't do that. Wanda recently had a gynecological checkup. It has nothing to do with the injury at work. We want to make sure that the gynecology records are not copied.
So we follow the minimum necessary rule.
Well, not exactly. It doesn't apply because workers' comp is excluded from HIPAA. I prepared a cover letter with further instructions. This suggestion came from the OCR website. We can use a letter to clarify the disclosure as long as it doesn't expand the scope of the authorization.
That's fine. I'll follow your instructions. And I'll take care of this right away.
HIPAA authorizations are regulated by federal and state law. Ordinarily, you follow both. But workers' compensation is an exception governed entirely by state law. Thanks for watching. We have more tutorials coming. Please send comments and suggestions to help us serve you better.